Good day, Crime Talk aficionados. We have a great show for you today. Sorry I missed yesterday. It was just one of those days in court. First on the docket, though, the grand jury proceedings get a little spicy in the Celeste Rivas Hernandez death investigation. You know, the one involving that singer David, spelled with a 4. Guess what? Bryan Kohberger, he's probably going to profit from the Idaho student murder story, despite his life sentence. The defense rests its case in the Brian Walshe murder trial without calling a single witness. A Colorado man accused of killing his baby mama and concealing her body in a shopping cart for several days, because, you know, that's normal. A man was arrested for allegedly assaulting a defense attorney in a courthouse here in Colorado, and the guy that got beat up, he's a friend of mine. We've got this day in legal history, our legal quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. I apologize. We did not do a show yesterday. I thought it was going to be a easy day. And this is exactly why I, always wear a suit, even when I think I'm not going to go to court. It was going to be a simple proffer. Of course, I'd always wear a suit to a proffer. And then I had to go to another jail to talk to a client regarding some negotiations. Then I got a call saying, "Oh, old client in federal court, be there at 2. And the case didn't even get called till almost 3:30. Then I had to do another call with an expert witness on a case. And I hadn't even made it to the office yet by about 4:30. So it simply wasn't going to happen. So my apologies. We'll try not to let it happen again. And today, you know, I wish I should do like a day in the life of me. All right. For example, go to court today, wait patiently. Client doesn't show up. Of course, client calls me hour and a half later after they've been, FTA'd. Sorry, I got my courtrooms mixed up. Okay, well, I have to do something. And then I got to go on a 2-hour drive to see a client in a jail this afternoon. Let me send one of my other attorneys. Let me see if we can still get you there, but you still may get arrested. You just never know what's going to happen, ladies and gentlemen, no matter how, like we talked about this the other night when I was doing the live. What I love about this job is you never know what's going to happen, and it's never the same day twice. The tough thing about the job is you never know what's going to happen, and it's never the same day twice. But when something blows up, it's like I can't just drop everything because somebody else was not following the rules, so to speak, right? Court appearance is mandatory. It's not a would you show up, it's you shall appear. It's a court order to show up. And if you can't show up on time and you can't follow the rules of the court and modern civilized society to show up on time, what am I supposed to do? It just drives me nuts. And I'm sure, when my attorney gets back from the office, somehow it'll be our fault. She didn't communicate with us, but I digress. All right. Let me remind you, go to crimetalksearch.com, sign up for the background subscription service today. When you do, you'll be able to get a background report prepared literally while you wait. The results are emailed to you. And you're going to find out social media presence, emails, phone numbers. You're going to find out if somebody has a criminal history, married, divorced, liens, judgments, everything that you want to know about somebody. Go to crimetalksearch.com. Also, let me remind you, go get your merch. Christmas is coming, ladies and gentlemen. We need to move this stuff. So go to check out the link below. It's good stuff for Christmas. Your spouse or significant other is probably not going to get you what you want, which is Crime Talk merchandise. So you got to do it yourself. Take matters into your own hands. All right, let's go ahead and open the record for December 11th, 2025. And first on the docket, things got a little spicy at the grand jury proceedings in regards to the death of Celeste Rivas. So some details have emerged from an ongoing grand jury investigation into the death of 15-year-old Celeste Rivas Hernandez, whose remains were discovered back in September of this year inside a Tesla vehicle, which was registered to singer David, spelled with a 4. His real name is David Anthony Burke. And if he is charged, and we're not saying he will be, but if he's charged, that's how it will appear on the charging documents, David Anthony Burke. Anyway, the case, which has obviously drawn some public attention, continues to unfold amid reports of witness non-cooperation, and heightened prosecutorial scrutiny. So what's going on? So on September 8th, 2025, the Los Angeles Police Department recovered the partially dismembered body of Celeste Rivas Hernandez from the front trunk of an abandoned Tesla bearing Texas license plates. The vehicle had been impounded in Hollywood after being left in the Hollywood Hills area, and then police were alerted to a foul odor emanating from the car, which had been at the impound lot for several days. The remains were contained in a bag and described by sources as partially frozen and in an advanced state of decomposition. Now, there's been some conflicting reports on that, even from the Los Angeles Police Department, that said that wasn't true. So we'll have to wait and see what the true facts turn out to be. So like I said, conflicting reports have surfaced regarding the condition of the body. Some sources initially claimed the remains were decapitated and severed into pieces, potentially complicating the determination of the cause of death by the medical examiner. However, the Los Angeles Police Department subsequently clarified to local media that the body was partially dismembered but not decapitated, and disputes surrounding claims of freezing remain, well, somewhat unresolved. But law enforcement from the Los Angeles Police Department and the District Attorney's Office have formally identified David as a suspect in what they have characterized as a murder investigation. You think? At the time, well, I guess, maybe she could have been like the Brian Walshe case, right? Suffered a medical emergency, and instead of calling for help, let's just put her in the trunk of the car, partially dismember her, right? Makes complete sense, does it not? Anyway, at the time of the discovery, the 20-year-old artist was on tour promoting his debut studio album, and sources indicate that that David initially cooperated with investigators, but has since ceased cooperation. No formal charges have been filed against him, and representatives for David have declined to comment publicly on the matter. Obviously, he's entitled to the presumption of innocence, although he's a suspect, he has not been charged. Now, additional reporting suggests the involvement of at least one other individual, potentially in the disposal of the body, though no further details about the second suspect have been officially confirmed. So what happened with the grand jury? So the Los Angeles County Deputy District Attorney Beth Silverman is presenting evidence to the grand jury. Recent proceedings have been marked by, well, some tension, particularly surrounding testimony from individuals connected to David's management. So Robert Morgenroth, general manager of Mogul Vision's record label and David's manager, testified over multiple days, including a session on Monday, December 8th. Now, during questioning, Silverman reportedly pressed Morgenroth on why he did not contact law enforcement about learning of circumstances related to the discovery regarding the body. And according to accounts overheard in the courthouse hallway, so take that for what it's worth, Morgenroth responded that he did not believe it was his responsibility to notify police and expressed a desire to prioritize continuing David's tour schedule. Further complications arose this week when an unidentified female witness, represented by the same attorney as Morgenroth, and the attorney is Evan Jennes, Jennes, failed to appear for scheduled testimony. The deputy district attorney, Silverman, informed the attorney that she intended to seek a body attachment order, which is a order to go have the marshals pick her up and bring her towards the grand jury. So, and as of December 11th, the grand jury continues its deliberations, obviously in secret, with no indictment publicly announced as of yet. The case remains active, and authorities have not released additional details about potential motives or the exact timeline of the events leading to the death of Rivas. Now, obviously, we're dealing with celebrity figures and uncooperative witnesses. That is normal when you basically have a grand jury investigation. It's not uncommon for people to not want to appear before the grand jury because, well, their friends, their family are involved, and they don't want to be the ones that basically gets somebody indicted. But that's the whole purpose of the grand jury, is to force people to show up and answer questions under oath, subject to the pains and penalties of perjuries if they lie, and also contempt if they refuse to show up. So it's interesting how a manager of David, well, I wasn't so concerned about, letting somebody know about a dead body wasn't my concern. I was focusing on the tour. Okay. I mean, I guess you have no duty to report a crime. But you would think, you'd probably want to do the right thing if you know somebody may be involved in a murder. We'll continue to follow that one. We'll see if an indictment comes down shortly. Next, yes, Bryan Kohberger. He can profit off of the deaths that he has been found responsible to have committed. So 3 years after the brutal stabbing deaths of the 4 University of Idaho students, the man responsible for the crime, Bryan Kohberger, is serving obviously multiple life sentences without the possibility of parole. Yet a little-known provision in the Idaho state law could still permit him to receive substantial financial compensation if he ever chooses to disclose previously undisclosed details of the November 13th, 2022 killings. Now, Kohberger obviously shocked the nation back in July of 2025 when he abruptly changed his plea of guilty on the eve of trial for the murders of Madison Mogen, Kaylee Gonzalez, Xana Kernodle, and Ethan Chapin. Now, during the sentencing hearing, he declined the court's invitation to explain his motives, leaving victims' families and the public without answers as to the central question of why the hell did he do it? And in a recent ruling ordering Kohberger to pay additional restitution to the victims' families, the Judge Hippler, included an unusual footnote stating, Idaho's version of the so-called Son of Sam law does not permanently bar a convicted defendant from eventually receiving proceeds from books, films, interviews, or other media that recount the crime, provided certain conditions are met. Under Idaho Code, Section 19-5301 requires that any money earned by a convicted felon from expressive work about the offense be diverted to an escrow account managed by the state treasurer. Victims of their estates then have 5 years to file civil claims, such as wrongful death suits or additional restitution orders against those funds. If no successful claims are made within that window and all existing court-ordered restitution has been satisfied, any remaining balances must be released to the defendant. The statute emphasizes that in practice, victims' families almost always prevail in such cases. Now, given the gravity of the offenses and the likelihood of a multi-million-dollar civil judgment, it's also highly improbable that Kohberger would ever personally receive a penny. Nevertheless, the mere existence of the 5-year window means Kohberger retains a theoretical pathway to profit off of his crimes, a prospect that has obviously angered the survivors and advocates who argue it forces grieving families to remain tethered to the legal system. Now, separate provisions in the Idaho law create additional avenues for money to reach Kohberger indirectly. Unlike some states that have recently broadened restrictions to include immediate relatives, Idaho currently places no prohibition on family members entering into media contracts about the case. Funds earned by the parents or siblings could lawfully be used to support Kohberger's prison commissary account or other incidental expenses, provided authorities do not deem the transfers as an attempt to circumvent the statute. Now, court records already show that between December of 2022, when he got arrested, and July 2025 sentencing, Kohberger has received approximately $28,000 in his jail account deposit, much of it from public donations and from family members. Judge Hippler noted in his latest order describing future donations as prison wages as foreseeable. Now, Kohberger is currently housed in a protective solitary confinement pod at the Idaho Maximum Security Institution, and Kohberger has a limited ability to collaborate on media projects, and corrections officials confirm he spends 23 hours per day in his cell and is tightly restricted in regards to visitation and communication privileges. So the fact that he's going to do a book in the near future, probably pretty unlikely, but needless to say, victim advocates have called on the Idaho legislature to close these gaps. Similar reforms were introduced in New York after the estranged wife of accused Gilgo Beach serial killer Rex Heuermann reportedly received a 7-figure compensation package for participation in a streaming docu-series. As one of the family members stated outside the Latah County Courthouse last week, we shouldn't have to keep fighting him in court forever just to prevent him from turning our tragedy into his payday. Next, Brian Walshe case. The defense rests without calling a witness. Boy, did anybody see that one coming? I did. In a swift and expected turn, at least by me. The defense team for Bryan Walshe concluded its presentation on Thursday without summoning a single witness, paving the way for final jury instructions and closing arguments, which will be scheduled for Friday in the high-profile first-degree murder trial of Bryan Walshe. Yes, Walshe faces charges in the death of his wife, Anna Walshe, whose body has never been recovered, despite a search for that, well, because we know Bryan Walshe admitted to chopping her up and disposing of her due to this undisclosed medical emergency. But that evidence was never presented, so I'm not sure how they're going to be able to argue that in closing. This decision marked a departure from earlier indications that the defense might call expert witnesses on the alleged sudden unexplained death, or even have Walshe testify personally. So during a brief courtroom colloquy with the judge, Walshe confirmed his choice not to take the stand, obviously a right protected under the Fifth Amendment, a very personal decision. Although he should listen to his attorneys, it's ultimately his decision whether he testifies or not. So the defense rests, the attorney Larry Tipton stated succinctly after the jury entered the courtroom at about 9:10 a.m., prompting the jury's dismissal for the day. So this development caps 2 days of intense testimony dominated by the prosecution's forensic and interpersonal evidence, which aimed to establish Walshe's culpability in what police described as a calculated killing motivated by marital discord. Prosecutors rested their case Wednesday afternoon following emotional accounts from Anna Walshe's close friends, underscoring the couple's strained relationship in the weeks leading to her ultimately vanishing. So Tuesday's session, the seventh day of witness examinations, centered on meticulous DNA analysis linking Anna Walshe to incriminating items recovered during the investigation. Forensic scientists from the Massachusetts State Police Crime Laboratory, including Saman Salim and Matthew Sheehan, described their findings under direct and cross-examination. Salim testified that DNA profiles extracted from a bloodied white towel, the blade of a hacksaw, a strained carpet fragment, a hair cluster, and a fragment of human tissue, all retrieved from garbage bags discarded near Walshe's mother's residence, were at least 30 nonillion times more likely to originate from Anna Walshe than from an unrelated individual. Additional mixtures on a Tyvek protected suit and bloodstained slippers implicated both spouses as contributors, with probabilities exceeding 1 in 73 quintillion for Anna's inclusion. Sheehan elaborated on presumptive blood tests conducted at the Walshe family home, revealing traces of basement flooring, a concealed kitchen knife, and various tools. Defense counsel pressed Sheehan on the test limitations, highlighting that they detect presumptive indicators rather than confirming human blood or pinpointing the time that the DNA was deposited. Arguments intended to sow doubt about the evidence reliability, obviously. Anyway, prosecutors supplemented the forensics with surveillance footage from a home goods store capturing Walshe on January 2nd of 2023, purchasing rolled rugs and towels using gift cards traceable to Anna's prior refunds. A store representative authenticated the transactions, tying it to its efforts by Mr. Walshe to conceal the post-disappearance cleanup. Now, these revelations built on prior evidence, including Walshe's January 1 purchase of cleaning agents, a hatchet, and a mop at a Lowe's store, totaling $450 in cash, amid internet queries such as methods for disposing of human remains. Now, Wednesday, the prosecution's penultimate day shifted to human elements, invoking visible distress in the courtroom as two of Anna Walshe's confidants recounted her final days. Proceedings began outside the jury's presence with Jem Mutlu, Anna's former employer and a family friend who joined the Walshes for New Year's Eve celebration at their home. Now, Mutlu, visibly emotional, described a jovial evening with no overt signs of conflict, departing between 1 a.m. at 1:30 a.m. on January 1st. Now, 4 days later, Walshe contacted him about Anna's absence, prompting Mutlu's pointed query about any arguments. Walsh's reply, no. Did it look like we had an argument? You were there, struck Mutlu as evasive, leading him to urge police involvement and community alerts. Now, Alyssa Kirby, Anna's Washington, D.C.-based best friend, followed with tearful recollections of their December 29th, 2022 encounter, the last time that she saw Anna alive. Kirby portrayed a marriage frayed by prolonged strain, with Anna expressing profound frustration and a sense of reaching a breaking point. Now, during cross-examination, Kirby acknowledged Anna's recent admission of waning affection, noting her response to Walsh's inquiries about her love, not so much, amid accumulating resentments. Now, these accounts painted a portrait of relational deterioration, contrasting the defense narratives that Anna succumbed to an unforeseen medical event in bed, triggering Walsh's panicked cover-up. Now, earlier this week, the defense had signaled plans for specialists in unexpected deaths, but those evaporated with Thursday's abrupt rest of their case. Post-testimony, the defense moved for a motion for judgment of acquittal, contending insufficient proof of the murder. The judge denied that, affirming the evidence adequate for the jury to consider. So what takes place now? With both sides now concluding after 8 days of prosecution witnesses, the trial advances to the climactic phase, juror sequestration from the media, return Friday for instructions from the judge, including premeditation and Walsh's prior guilty pleas to dismemberment and evidence tampering, admissions that concede Anna's death but contest its cause. Closing arguments will frame the prosecution's circumstantial web of forensic surveillance and motive against the defense's emphasis on evidentiary gaps and alternate explanations. If convicted, Walshe faces life imprisonment without the possibility of parole. Obviously, the case is rooted in a disappearance that mobilized local and federal resources, remain a reminder of unresolved loss, and Anna's remains elude discovery 2 years on. I'm not sure why the defense did this. I get it. Nobody wants to plead guilty to killing your wife, particularly if you have children, right? I've seen people go down because they will not admit that they did something, and they will go to their graves denying it for whatever reasons. Usually it's family related. So I get why he's like, okay, yeah, I chopped up my wife, kids, so forgive me, kids, but I didn't kill your mother. But if the jury says you did, well, you did. All right. The defense is screwed. They got nothing. Oh, circumstantial evidence. And then they're going to hear about the admissions of chopping her up. But there's been no evidence presented as it relates to testimony that they were expecting to hear. That's what the jury was expecting to hear as it relates to unexpected deaths. Nothing. Zip, zilch, nada, nothing. And the prosecution, delivered on what they promised in opening statements. The defense now is going to be perceived as, well, not being truthful in front of the jury because you said it was this accidental event. Where's the evidence? None. They should not be allowed to argue that at all. Complete speculation, zero evidence presented at all, and therefore should never be mentioned in closing arguments. Walshe had his chance to tell his side of the story. He didn't do it. Guess what? He's screwed. Next, a Colorado man accused of killing his baby mama. I hate that word, but that's what they refer to him as. And then concealing a body in a shopping cart, because that's normal behavior, right? So Westminster, Colorado, technically where our offices are located. So police in Westminster have arrested a homeless man with an extensive criminal history on suspicion of murdering his former partner, the mother of his 3 children, and subsequently transporting her remains in a shopping cart over several days before disposing of them in a trash receptacle. Thomas Perales faces potential charges of second-degree murder, abuse of a corpse, and violation of a protection order in connection with the death of 37-year-old Annette Maria Valdez, who was reported missing on Thanksgiving Day, and her body was discovered on December 4th inside a large outdoor trash container near a local supermarket. According to the arrest affidavit, Perales admitted to investigators that he blacked out during a heated argument with Valdez inside of her apartment. He described placing her in a headlock and covering her mouth with his hand upon later realizing that she was deceased. Perales reportedly wrapped the body in blankets, retrieved a trash can from behind a nearby Safeway store, and used a shopping cart to move the remains around the area for multiple days before ultimately throwing her in the trash. Witness accounts from members of the local homeless community relayed through Valdez's family indicated that Perales was observed pushing a shopping cart containing a bundle form during this period. Valdez's brother, Adam Larson, informed detectives that individuals experiencing homelessness had informed the family of these disturbing sightings. A preliminary autopsy revealed injuries to Valdez's neck consistent with pre-mortem trauma, though advanced decomposition prevented a more definitive initial examination. Court records and police reports paint a troubling picture of ongoing domestic turmoil. Valdez has obtained multiple protection orders against Perales, which he allegedly violated on numerous occasions. And in the 2 years preceding her death, law enforcement responded to her residence 67 times, including 9 calls specifically related to domestic violence incidents. As recently as October of 2025, Perales allegedly attempted to force entry into Valdez's apartment using a knife, damaging the door, and smeared red paint over her Ring doorbell camera and peephole. He was arrested at the scene and charged with domestic violence related to that offense. And then on November 21st of this year, just 6 days before Valdez was last seen, an Adams County judge sentenced him to 12 months of probation and ordered him released from custody. Family members had expressed a longstanding concern over Valdez's continued contact with Perales despite the history of abuse. Apparently, the family said they tried everything to keep her away from him. Larson, she also went back to him because he was the father of her children. Now, Valdez leaves behind 3 young daughters who are now staying with relatives during the holiday season. Relatives described the challenge of explaining the tragedy to the children at Christmas time, well, somewhat difficult. Perales remains in custody. Prosecutors with the Adams County District Attorney's Office are expecting to file formal charges in the coming days. He was scheduled for an initial appearance yesterday, and the case obviously goes to enforcement of protection order violations, ladies and gentlemen. And let me tell you, I've had experience with Westminster. You can say, hey, look, somebody's violating a protection order. Westminster, here it is. I'm serving this up to you on a silver platter. And they'll be like, well, it's a lot of work. They're really out of state. Do you really... See, this is what happens. If you don't force the small stuff, bigger stuff happens. And Westminster, if you're listening, this is what I've been warning you about. Not on this case. I have no involvement with this case, but on the case that I'm thinking about, keep telling you the person has a protection order, and what are you going to do about it when they're violated? What is it going to take? What is it going to take for somebody to do that? Next, a man was arrested in court for assaulting a defense attorney who is a friend of mine. Yeah, listen to this story. So a 36-year-old Aurora, Colorado resident, a guy by the name of Daniel Alexander Ashby, has been detained in the Arapahoe County Jail on suspicion of second-degree assault following alleged physical attack on the defense attorney outside of the courtroom on Monday afternoon. So this incident reportedly occurred prior to a scheduled hearing related to the July 2024 death of Ashby's 12-year-old nephew, who was fatally struck by a vehicle while riding an electric scooter in a marked crosswalk at East Iliff Avenue in Aurora, Colorado. According to police, the boy had activated the pedestrian crossing signal when 19-year-old Christopher Ramirez Rodriguez allegedly ran the red light, striking and killing the 12-year-old. Ramirez Rodriguez faces charges for careless resulting in death. Now, the attorney involved, 69-year-old H. Michael Steinberg, who I know, who I literally was in court with last week, sat next to him, and we chatted. We caught up regarding his family. He's always been gracious, asked about my children. I asked about his. Both of his children are attorneys. His son is actually a prosecutor in Arapahoe County this time. Michael Steinberg. longtime prosecutor, longtime criminal defense attorney. Nice guy. Okay. Anyway, so court documents and the police reports indicate that Ashby approached Steinberg aggressively in a courthouse hallway in an apparent attempt to identify the defendant. Steinberg reportedly instructed Ashby to enter the courthouse and physically pushed him away to create some distance. In response, Ashby allegedly executed a forceful takedown maneuver described by police as an MMA style that rendered Steinberg unconscious. Steinberg was transported by ambulance to a local hospital where he was diagnosed with multiple spinal fractures and a shattered pelvis. Now, in correspondence with the media, Steinberg confirmed that he remained hospitalized in significant pain and was going to have surgery done today. Now, apparently, there's no security footage of the hallway confrontation, according to the Arapahoe County Courthouse, because what courthouse doesn't have cameras in the hallway? Anyway, the Arapahoe County Assistant District Attorney described courthouse violence as exceedingly rare, noting that physical confrontation involving attorneys, prosecutors, or judges are highly unusual despite, obviously, emotional charged environment as it relates to criminal proceedings. Well, Mr. Ashby has been taken into custody at the scene and is being held on a $75,000 bond. He apparently has no prior criminal history that includes multiple violations of protection orders resulting in previous incarceration. So family members of both the victim and the defendant have regularly attended hearings in the crash, and Michael Ashby, the arrested man's older brother, told reporters that the family has experienced ongoing frustration with the judicial process and acknowledged tension with the suspect's relatives. Following the incident, the presiding judge reportedly cautioned both families against attempting to take justice into their own hands. Prosecutors are currently reviewing the evidence to determine formal charges. Ashby is scheduled to appear in court on Friday in regards to filing of charges. Unbelievable, ladies and gentlemen. I can honestly say I've never been assaulted in a courthouse. Had some mean, nasty looks over the years. I assure you of that. Once had a guy, as I was walking out of this very courthouse, the Arapahoe County Courthouse, it was a homicide case, which I might note we won, got a not guilty on. But as I was walking to my car, the family in the next lane over in the parking lot made a gun movement and pointed it at me. And, I called the district attorney and I said, hey, just tell your family members, I'm just doing my job. Let's keep it that way. District attorney's like, yeah, I'll talk with them. Well, then the DA calls me back. Hey, do you want an escort in and out of the courthouse? The family members are pretty bad dudes because, apparently my client had killed like some cartel member's family and they wanted to take revenge and all that kind of good stuff. But needless to say, we went to trial and our client was acquitted of first-degree murder. But you never know. Emotions run high in courtrooms. It's always a difficult situation, particularly when there's a death involved, particularly that of a child. Everybody shows up supporting everybody. Emotions run high. Usually the deputies have one side of the dispute leave first. The other side waits, gives them 5-minute head start so that everybody can get to their cars and then leave. But apparently that didn't take place today, or apparently that didn't take place that day. Next on the docket, this day in legal history, December 11th, 1941. Germany and Italy declare war on the United States. And on December 11th, 1941, the United States declared war on Germany, Italy, and Japan. Obviously, shortly right after World War II involvement began as it related to the bombing of American fleet in Hawaii. Next, on this day in 1922, the United States Supreme Court held that a Pennsylvania statute limiting coal mining could amount to a taking under the Fifth Amendment if regulation goes too far in diminishing property value, launching the modern regulatory taking doctrine, right? Government cannot take your property without due process and compensation, right? Fifth Amendment right. So way back then in the 20s, even then they were saying, hey, government, if you overregulate something and I can't use my property, you have to pay me for it. Regulatory taking. On this date in 2013, Kansas v. Cheever, the court unanimously held that when a defendant presents expert testimony that his mental condition negated mens rea, the prosecution may introduce evidence from a court-ordered psychiatric exam to rebut that claim without violating the self-incrimination clause, right? So if somebody says not guilty by reason of insanity, they get evaluated by a doctor. And if the defense raises that, well, then they can introduce statements made by the defendant to the doctor during those evaluations to rebut that. Next, our legal quote of the day. It is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. So this obviously establishes the principle of judicial review and the power of the court to declare acts of Congress and the executive branch unconstitutional and remain the cornerstone of American constitutional law. Now remember, it has to actually be unconstitutional. Just because the judge doesn't like a policy change doesn't mean that it is unconstitutional. And it doesn't mean that a shift in policy is breaking the law. It's a policy. Remember, the executive branch can do that. Just remember that. And finally, our dumb criminal of the day. Let's go to Door County, Wisconsin, where a driver was issued a traffic citation after deputies discovered a handheld flashlight being used in place of a missing headlight during a routine traffic stop. That's right. The Door County Sheriff's Office reported that the vehicle was initially pulled over for exceeding the speed limit on the highway late Monday evening. Upon approaching the car, deputies observed that the driver's side headlight was inoperative, with a standard flashlight positioned and aimed forward in an apparent effort to provide illumination. Police stated that although the improvised solution demonstrated initiative, and I agree, a portable flashlight does not meet the legal or safety standards for automotive lighting. Proper headlights are essential for both seeing the road and ensuring that other vehicles see you as well. Anyway, the sheriff's office reminded the public to conduct regular safety checks of your vehicle equipment, including lights, brakes, and tires, to comply with traffic laws and prevent hazards. No injuries were reported in the incident. I agree with the sheriffs here. Good initiative, poor judgment, but we like your style. At least you were thinking. And I forgot to mention this. We got a bonus. That's right. The battle box has arrived. You say, has it already been a month since the last battle box? Yes. Now you will notice I have one battle box. This is completely sealed, so I don't know what is in the battle box either, ladies and gentlemen. So we're going to find out together. All right. So fortunately, I just happen to have a K-bar here at my desk, and we will open this. Now remember, this is for the first time. This is not a paid promotion. This is just something that I signed up years ago. I think somebody got it for me. I kept it going. I don't know exactly why, but we do know that it usually has sharp objects in it, which, hey, who doesn't like a good sharp object on a monthly basis? So let's see what we get in the battle box. Oh, got some more tape we got to undo. Can you hardly wait? Oh my goodness. Frank. Oh my gosh. Let's see. First, oh, speaking of headlights, we can always tape this to the car if we need it, apparently. It's a Flex Beam 1200 lumens light, best for spotlights or flood options. Look at that. I think I got one of these already, but that's all right. Let's see next what we've got. There's usually a book in here that describes what we get. So let's see. The battle box book. Okay, this is better than Christmas, and it comes every year. So that's the PowerTac Flex Beam flashlight. Good set of gear. What do we got next here? Oh boy, this is big. Oh boy. Well, let's go to this because it's on top. We've got a grill, the Pull Start Fire Grill, because you never know when you're going to need it. It's a pull start. Huh. Cold weather, wet ground, frozen hands, none of it matter. The pull start fire grill makes fire starting simple. Pull the string, wait 5 minutes, and you're ready to cook. No lighter fluid, no frustration, no fail. Its solid charcoal brick burns for up to 3 hours, delivering consistent heat across the grill. That's long enough to cook, thaw, or just warm up your spirits. There you go. You never know, because you never know what's going to happen. Catastrophe could take place. All right, let's see here. This is the Mountain Ops Adventure Blanket. You can't out-hike cold, but you can outsmart it. The Mountain Ops blanket is lightweight, durable, and insulated with 200 GSM synthetic fill to trap heat without adding bulk. Use the collar clips to go hands-free or take down. So you never know. Throw that in the car, right? The winter is here. I got to go drive 2 hours in the middle of nowhere. I should probably throw that in there. What if I have accident issues, right? What if I have car issues and I don't want to freeze and die in the middle of nowhere, right? Next item up today, midweight merino wool OTC socks, cold feet and missions early. That's why the midweight merino wool over the calf socks are built to perform, not just comfort. Now, let me tell you, this is the biggest selling point I would take of this. Over the calf socks. All right. People always ask me, my kids, Dad, what can we get you for Christmas? Black over the calf socks. Why? Because if you're sitting in court, you don't want a little sock to be showing, your leg after that. You got to have over the calf. So these are apparently warm and they're over the calf. So that's already a selling point. Just remember that. You can't have your legs showing when you're in court. What have we got here? Bison stew. Wow. Nothing fights the cold like a real meal. Field Fuels Hearty Bison Stew packs 43 grams of protein into rich-based stew. No preservatives, no gluten, no junk, just clean, honest fuel. There you go. Heat it up and go. It's like an MRE. And the final item, there's always got to be something sharp, at least in my Battle Box edition. This looks like the ox bone fish blade. Oh, it's sealed. We live dangerously here, ladies and gentlemen. We live dangerously. Oh, look at this. Nice little leather carrying case. And what does it say? The season that demands reliability. The Russ Comer Ox Bone Fixed Blade delivers its D2 steel blade, strong enough to split wood, dress game, and handle any cold weather task you throw at it. The genuine ox bone handle gives it a timeless look with a grip that feels as solid as it looks. At 8 inches overall with 3.75-inch blade, it is the right size for daily carry and serious field work. Look at that bad boy. There it is. Just, I guess it won't fall over. And we tried. Anyway, always got to have sharp things in your battle box, right? You never know when you may need an extra knife. And now I probably have, 40 of these different things. So it keeps it continuing. All right, ladies and gentlemen, that's all we have for today. Thanks for watching. Hope you enjoyed the show and the bonus battle box. We'll see you tomorrow. And remember, the Constitution matters.